Cornell Law School. UCC. Article 2, Sales. Part 6. Breach, repudiation and excuse. Paragraph 2601. Buyer's rights on improper delivery. Subject to the provisions of this article on breach and installment contracts, Section 2612, and unless otherwise agreed under the sections on contractual limitations of remedy, Sections 2718 and 2719, if the goods or the tender of delivery fail in any respect to conform to the contract, the buyer may A. reject the whole, or B. accept the whole, or C. accept any commercial unit or units and reject the rest. Paragraph 2602. Manner and effect of rightful rejection. 1. Rejection of goods must be within a reasonable time after their delivery or tender. It is ineffective unless the buyer seasonably notifies the seller. 2. Subject to the provisions of the two following sections on rejected goods, Sections 2603 and 2604. A. After rejection, any exercise of ownership by the buyer with respect to any commercial unit is wrongful as against the seller, and B. If the buyer has before rejection taken physical possession of goods in which he does not have a security interest under the provisions of this article, subsection 3 of Section 2711, he is under a duty after rejection to hold them with reasonable care at the seller's disposition for a time sufficient to permit the seller to remove them, but C. The buyer has no further obligations with regard to goods rightfully rejected. 3. The seller's rights with respect to goods wrongfully rejected are governed by the provisions of this article on seller's remedies in general, Section 2703. Paragraph 2603. Merchant buyer's duties as to rightfully rejected goods. 1. Subject to any security interest in the buyer, subsection 3 of Section 2711. When the seller has no agent or place of business at the market of rejection, a merchant buyer is under a duty after rejection of goods in his possession or control to follow any reasonable instructions received from the seller with respect to the goods, and in the absence of such instructions to make reasonable efforts to sell them for the seller's account if they are perishable or threaten to decline in value speedily. Instructions are not reasonable if on-demand indemnity for expenses is not forthcoming. 2. When the buyer sells goods under subsection 1, he is entitled to reimbursement from the seller out of the proceeds for reasonable expenses of caring for and selling them, and if the expenses include no selling commission, then to such commission as is usual in the trade, or if there is none, to a reasonable sum not exceeding 10% on the gross proceeds. 3. In complying with this section, the buyer is held only to good faith, and good faith conduct hereunder is neither acceptance nor conversion nor the basis of an action for damages. Paragraph 2604. Buyer's options as to salvage of rightfully rejected goods. Subject to the provisions of the immediately preceding section on perishables, if the seller gives no instructions within a reasonable time after notification of rejection, the buyer may store the rejected goods for the seller's account, or reship them to him or resell them for the seller's account, with reimbursement as provided in the preceding section. Such action is not acceptance or conversion. Paragraph 2605. Waiver of buyer's objections by failure to particularize. 1. The buyer's failure to state in connection with rejection a particular defect which is ascertainable by reasonable inspection precludes him from relying on the unstated defect to justify rejection or to establish breach, A. Where the seller could have cured it if stated seasonably, or B. Between merchants when the seller has after rejection made a request in writing for a full and final written statement of all defects on which the buyer proposes to rely. 2. Payment against documents made without reservation of rights precludes recovery of the payment for defects apparent on the face of the documents. Paragraph 2606. What constitutes acceptance of goods? 1. Acceptance of goods occurs when the buyer, A. After a reasonable opportunity to inspect the goods signifies to the seller that the goods are conforming or that he will take or retain them in spite of their nonconformity, or B. fails to make an effective rejection, subsection 1 of section 2602, but such acceptance does not occur until the buyer has had a reasonable opportunity to inspect them, or C. does any act inconsistent with the seller's ownership. But if such act is wrongful as against the seller, it is an acceptance only if ratified by him. 2. Acceptance of a part of any commercial unit is acceptance of that entire unit. Paragraph 2607. Effect of acceptance. Notice of breach. Burden of establishing breach after acceptance. Notice of claim or litigation to person answerable over. 1. The buyer must pay at the contract rate for any goods accepted. 2. Acceptance of goods by the buyer precludes rejection of the goods accepted, and if made with knowledge of a nonconformity cannot be revoked because of it unless the acceptance was on the reasonable assumption that the nonconformity would be seasonably cured, but acceptance does not of itself impair any other remedy provided by this article for nonconformity. 3. Where a tender has been accepted, A. The buyer must within a reasonable time after he discovers or should have discovered any breach notify the seller of breach or be barred from any remedy, and B. If the claim is one for infringement or the like, subsection 3 of section 2312, and the buyer is sued as a result of such a breach, he must so notify the seller within a reasonable time after he receives notice of the litigation or be barred from any remedy over for liability established by the litigation. 4. The burden is on the buyer to establish any breach with respect to the goods accepted. 5. Where the buyer is sued for breach of a warranty or other obligation for which his seller is answerable over, A. He may give his seller written notice of the litigation. If the notice states that the seller may come in and defend, and that if the seller does not do so he will be bound in any action against him by his buyer by any determination of fact common to the two litigations, then unless the seller after seasonable receipt of the notice does come in and defend he is so bound. B. If the claim is one for infringement or the like, subsection 3 of section 2312, the original seller may demand in writing that his buyer turn over to him control of the litigation including settlement or else be barred from any remedy over, and if he also agrees to bear all expense and to satisfy any adverse judgment, then unless the buyer after seasonable receipt of the demand does turn over control, the buyer is so barred. 6. The provisions of subsections 3, 4, and 5 apply to any obligation of a buyer to hold the seller harmless against infringement or the like, subsection 3 of section 2312. Paragraph 2608. Revocation of acceptance in whole or in part. 1. The buyer may revoke his acceptance of a lot or commercial unit whose nonconformity substantially impairs its value to him if he has accepted it, A. on the reasonable assumption that its nonconformity would be cured and it has not been seasonably cured, or B. without discovery of such nonconformity if his acceptance was reasonably induced either by the difficulty of discovery before acceptance or by the seller's assurances. 2. Revocation of acceptance must occur within a reasonable time after the buyer discovers or should have discovered the ground for it and before any substantial change in condition of the goods which is not caused by their own defects. It is not effective until the buyer notifies the seller of it. 3. A buyer who so revokes has the same rights and duties with regard to the goods involved as if he had rejected them.